Thank you for joining us. The following presentation is from a webinar titled Tweet, Follow, or Get Out of the Way, what every employer needs to know about social media and related legal claims. Originally produced on August 20th, 2015. The presenters are Greg Lowe from McKonly Asbury and Todd Schill from Rhodes & Sinan. Enjoy the presentation and visit us online at www.macpas.com for more information about our future events and upcoming webinars.
Thank you, Tyler, and welcome, Todd, to McKonly Asbury today.
Thank you, Greg.
It's been maybe 20 years. I've known Todd. We've worked together in a lot of different client matters through the years, and it's just a pleasure to have him here today to talk about an emerging topic. It seems like emerging may be an understatement, but the topic of just social media and what employers need to be thinking about, need to be considering in that realm. So, Todd, I'd like to turn it over to you. Just dive in, if you would, and get us started.
Yeah, glad to do it. Thank you for having me. You mentioned that we've known each other for about 20 years, and it feels to me as though social media has been around for 20 years, but it clearly is not. It has certainly dominated and taken over everything we do in the employment law world, as well as many other types of industries and practices. So I'm happy to talk about this topic. We've been very actively presenting on this topic for a number of years now, and literally changing on the moment. So one of the things I want to talk about, and you see it up on your first slide, is computers were certainly designed to make people more productive, but then someone invented the internet. And years ago, when I would get a call in my practice, I literally would get the call that, hey, I have an employee who's supposed to be working, but instead they're watching the NCAA basketball tournament on the internet. What do I do about that? I mean, that was the traditional call you got. They're supposed to be working, and here they are playing around on the internet, shopping, emailing their kids, that sort of thing. And we've gone well beyond this now. If you think about certain concepts in the social media and internet world, there's a concept out there called Web 1.0. And Web 1.0 is very similar to what I just described. It's a situation where the user would basically take information from the internet. So they'd watch a basketball game, or they would shop, or they would read news, but they weren't actually interacting back and forth with the internet and with other users. And that kind of very standard way of using the internet gave rise, again, to a lot of these productivity questions. In fact, whenever I talk about this, I always laugh because even today I actually do get those NCAA calls. CBS actually has they took notice of the fact that so many people are watching the NCAA tournament during the workday that if you watch the tournament on their websites, you'll see a button in the corner called the boss button. And what you do when you click that boss button is your computer screen goes right to a spreadsheet or an email to trick your boss into thinking you're actually working. So, that still is an issue, but the real issue that we're facing today is something that is in the realm of Web 2.0. And what I'd like to talk about today are some of the legal issues and the challenges employers have with the Web 2.0 applications you see in front of you right now. But we're also going to talk a little bit about something, and quite honestly, I haven't really discussed much of this before, but we're going to introduce you to a topic called Web 3.0 in a little bit here. But let's start at least with Web 2.0 and go from there. So now, we've moved from the situation where an employee is sitting on the internet during the day and taking information from the internet. And we've moved to a situation where they're communicating, they're offering information, they're having conversation with others, with users, they're posting, they're blogging, they're sending tweets, they're interacting. And the sites you see in front of you and the applications you see in front of you are really where most of my legal work seems to be these days. It used to be as an employment lawyer. Years ago, in a discrimination case, for example, you were looking for the memo that said you can't teach an old dog new tricks, or something that was, in written form that provided the smoking gun in the case. Now you're talking about getting a new case filed, and immediately lawyers are looking, and they're obligated to look, for social media posts. Why? Because this is where all of your employees are having conversation. They're not having conversation around the water cooler. They're not having it around the coffee machine or the Keurig machine, whatever you would call it these days. They're having them on these sites. And so let's take just a quick look at them, and we could talk a little bit about their use. Facebook, of course, you're all familiar with, 1.4 billion users or so. Twitter is up there with 550 million users. As we work our way sort of around this slide, you see Instagram sort of in the lower left, 300 million users on Instagram right now. 70 million for Pinterest at the bottom there. YouTube, 4 billion views per day or so. Google Plus at the bottom right, 600 million users. LinkedIn, 332 million, and it goes on and on and on. So if you sit there in the workplace and you think your employees are not using these sites, they are. And, when they first sort of broke on the scene, my clients would call me up and again say, hey, my employees, they should be working and they're using our servers to go onto Facebook or go onto Twitter. Well, now we know for certain that the majority of users of these sites are not using them through your servers. They're using them through their own mobile devices. Now we're up to about 71% or so of individuals are using mobile access to access these applications and these websites. It comes from the idea that the employees sort of get smart enough to know that they're being monitored by most employers these days, and therefore they're going to kind of skirt around that a little bit and try to, be on these sites at their leisure or whenever they get the opportunity. So they're doing it from their iPhones, they're doing it from their iPads, they're doing it from their home computers, their laptops. I mean, very difficult for employers anymore to sort of monitor and curb this behavior. In fact, most employers these days have moved away from those policies that say you can't be on the internet for things other than work-related purposes during the workday. Most employers have realized that's just not realistic. It's not what's happening, and most have gone through into some sort of incidental use policy. We know you're going to email your kids at school. We know you're going to shop. We know you're going to do this. But hey, focus on your work first and foremost, and we trust you to be adults in that respect. So, this is where, again, all the evidence is. The sexual harassment cases, the discrimination cases, the non-compete cases, the breach of fiduciary duty cases. Almost every employment law case you could think of goes right to these applications. This is where our evidence is. So much so to the point that when we get a new case filed, we are required to go out and preserve all electronic communications that we know of for a case. And a judge could very well sanction the lawyers and the client for not doing that. So electronic communications is really the name of the game. And for your purposes, think beyond email, think beyond even text messages. It goes right to the social media type of communications that we're going to discuss here today.
Can you? Well, I was just going to say. I mean, each of these technologies that you have referenced on this slide, there's probably millions of examples with each of those. And I know, without addressing client specifics, et cetera, could you take us through a couple, just to give us a flavor for the types of things you're talking about with any one of these in particular? Yeah,
absolutely. To begin with, I want to introduce a concept real quick for all of you called Web 3.0. And like I said, I don't know that I've even spoken about this yet, but it's something that I think really is starting to permeate my practice. And what that is 2.0, as we just described, is where the user is leaving information or interacting with other users. Now we have something called Web 3.0, which has been described by these social media scholars as the intelligent web. Now, what that means is that if you're out there and one of your employees puts information out on the internet, so to speak, or certain users out there will want to verify and check that information to the point where they think they have a responsibility to check credibility and to investigate and to out fallacies that employers may put out there or employees may put out there. And the best example I have of this is what you'll be looking at here on the screen here. I call this Reddit versus Applebee's because this was where I first saw this kind of Web 3.0 thing emerging. Reddit is a really interesting site in that you can sign up to be a Redditor, quote unquote, and what that means is as you go through the internet in your day and you see something interesting, you click on that page, and then it becomes sort of like a virtual dog ear where that page is saved. And the more people that save that page or click on that during the day, the higher it gets to the top of the Reddit stories. So I'll give you an example of how an employer can get in trouble here. In the Applebee's situation, there was an employee, a waitress, who received or served a pastor, and this is what she got instead of a tip, what you see in front of you. He wrote on the receipt, "I give God 10%, why should you get 18? And that's it, gave her 0. Now, years ago, before the internet, that was, she'd be upset and she'd crumple it up and throw it in the trash and that would be it. But nowadays, she did what a lot of people do. She goes and posts it on the internet to disparage, this particular customer. And she says in there at the top, "My mistake, sir. I'm sure Jesus will pay for my groceries and my rent." But she's making a point that, you can't just do this and get away with it anymore in the internet world. Well, immediately, in the 2.0 world, most of the time that would be out there and people would read it and it would go away. But now this frenzy's been created. And this is why I call it the intelligent web. We instantly get these stories you see in front of us. These, breaking news. Applebee's servers fired after posting this receipt. Because what happened is she posted the receipt and the employer reacted very quickly the way employers typically do. Instead of thinking through your obligations under the law and the reaction on social media and PR, they went ahead and fired the waitress right away for posting this customer's receipt. And of course, you see the news stories that emerged right away. And then Applebee's tries to smooth over this situation, which a lot of employers do, by taking their argument to the web. We wish this situation hadn't happened. Our guest personal information is private. Now, again, in years prior, when you say something like that, our guest personal information is private, people kind of let it go. They read it, moved on. But not anymore. Not under the world of Web 3.0 where you have these Redditors coming after you, these so-called investigators who love to out people on the internet. And right away, they go out and they find situations where Applebee's has posted customers' receipts all over the place, therefore demonstrating that when Applebee's says their guest personal information is private, including their meal check, they're not being accurate. Where a customer leaves them a big tip or a compliment about Applebee's, sure enough, they put it right on there. So here we go. The Redditors say, not only are we just going to out you, Applebee's, for the fact that you've been inaccurate here, we're going to go ahead and post this pastor's personal phone number on the internet. And again, this shows you how deep and how vicious some of the people can get on the internet. And this is why I think employers need to be really has to pay attention to how they handle employees. If you're going to take action against an employee for something they post on the internet, you have to think it through. Are you going to be challenged by the Redditors of the world, the users of the internet? Are you going to be outed for situations where maybe you contradicted yourself? And are you going to get yourself in a bigger PR mess by doing this? I have several cases I've had over the years where servers at restaurants have been fired over something that they said on the internet. And when those events start to be displayed publicly on the internet, you think, or the employer would think, that the people would understand the employer had to take action against this particular person. Absolutely not. The internet comes to the rescue of the employee and oftentimes makes the employer look bad, and in some instances has really done some damage to the employer. So when an employer wants to look at a post and take some action there, I always make them think, let's talk about the law for a minute, and then let's most importantly talk about PR, or what can happen to you down the road. And, this intelligent web concept, this is a great day to talk about these issues today, because for those of you who haven't read the stories about Ashley Madison and what's going on, go out there and Google it. You're going to see a situation where the investigators of the Web 3.0 people, are not going to let private information sit out there. Their main goal in life is to out individuals, out employers, and to embarrass people. And that's unfortunately the world we live in these days.
And your point sort of being this private interaction between a server and a guest was all of a sudden made, the jury, where the case in a sense was tried, is now the internet, with all kinds of unqualified or less than qualified jurors making the decision of whether or not to wreck the restaurant's business, whether to wreck the attendance of the pastor's church, or et cetera, et cetera. And it was all out of the company's hands before anything could be done about it.
Absolutely. Yeah. And that's a really great way to sum it up, because once this issue is out there publicly like this, you can't put it back in the bag. It's out there, and you got to, and all the PR you want to do, it snowballs, and you keep getting deeper and deeper and deeper. So I have these conversations a lot with employers who their first reaction is, I want to deal with it, I want to go out there, I want to make a public comment. And my point is, do ya? Because here's where it's going to go. So maybe sometimes it's best to say nothing and not attract the attention of these Redditors and these investigators on the internet.
Well, you talked a little bit about the Web 3.0 and the more intelligent web, and so now, of course, everybody's going to be dying to figure out what's the confession bit. What does that mean?
We talk about people who rush to place things on the internet, and a lot of what we're seeing, and human resources employees are seeing this all the time. they're getting information come back to them, maybe anonymously or through others saying, "Hey, I know who posted this." And it's difficult as an HR person to decide what you can rely on, what you can take as credible and not. And Confession Bear is one that caught my attention because I had a number of employer clients who would call me up and say, my employees are telling me that one of our coworkers, one of our employees, posted this awful confession on Confession Bear. And I said, well, what's Confession Bear? And they said, well, it's a meme that people create to disclose their most private secrets or things they're embarrassed of or things they want to get off their chest. So I'll give you one that I looked at right away. It became a criminal case out there with some notoriety. But a person goes out there on the internet and posts a meme of this Confession Bear who looks like he's sad and he wants to confess something and says, look, my sister had an abusive meth addict boyfriend. I killed him with his own drugs. Now, years ago, again, someone would probably read that and say it's a hoax or it's just, there's no credible information here. But in the day and age of the Redditors and the people who are out there on the web, you know what they did here? They found out. They hacked into this. They found out the IP address of this person who posted it. They went ahead and discovered who this person was, and they reported it to the police, and this person was arrested. So employees, I'll take it back to the private workplace, to outside of the criminal world. There are employees out there who are posting things about sexual harassment, about things they've done in the workplace, about their boss, all kinds of things you would never put out there. They throw it out there in a meme like this with a cute bear, and they think that no one's going to know about it. But in this day and age, based on Web 3.0 and the intelligent web, of course they're going to find out about it, and it could lead its way back to the employer.
Don't you think that this promise, the Internet's promise of anonymity is dying off, though? That don't you think people, employers, et cetera, by 2015, they're starting to realize that though it would appear anonymous, like the Applebee's one or even this one, that there's really less and less and less anonymity, around? Or do you think there's people who are still not, employers and employees alike, are just still not getting that? They think they really are anonymous, like the site that we just saw in the news recently about people were cheating on their spouses, et cetera, and were hacked, and now they're not anonymous anymore. They're out everywhere. Yeah,
it's a really good point because instinctively I say, my God, we live in the year 2015. You think based on all these high-profile news stories, that anything you put on the internet is subject to scrutiny and investigators and figuring out who you are. But then again, every time I train employers, I run into these situations where, there are certain employees who really have no idea. They think what they put out there is protected by the First Amendment or other types of laws. And, looking at your screen right here, this leads you right. This is a perfect example. Snapchat. Snapchat came on the market, and what Snapchat promises as an app is that the picture you send to the other user is self-destructs. Mission Impossible style, self-destructs, and it's gone forever. And that lulled a lot of people into this sense of security, saying, if I send this picture, I know no one would, it wouldn't be good if people saw this, but it's going to go away and never be heard of. And, the fact that they don't realize that not only is it captured on the Snapchat servers, but every user is savvy enough and quick enough to take a picture of that picture on their iPhone and then put that on Twitter, put that on Facebook. Nothing you send via the internet by Snapchat or other is private. And I have cases, harassment cases and some others, that absolutely turn on Snapchat pictures that the user thought would never be seen by anyone other than the user in that immediate 10 seconds. So while I think they should get it because of all the great examples out there, they're not getting it.
Well, let's dive into a little bit into probably the most prevalent one that comes up, or at least the one we hear about most often, Facebook. Right, and probably most of our listeners out there have Facebook pages. Most of the employees of the companies that we're talking to today have Facebook pages. Let's dig into Facebook a little bit.
Yeah, absolutely. This is my favorite part of a presentation like this, because when you see these posts, you're instantly going to say to yourself, "This can't be. These can't be real. I can't believe employees are so stupid. I can't believe employers are so stupid." But the truth is, they are real. I've taken what you're about to see from a website that I love and I credit it all the time. It's called lamebook.com. and they post a lot of this. They go out and capture, the dumb things that people say on Facebook, and they capture it at a site called lamebook.com. And I love it because these are great examples. But I will tell you, and I said it before the webinar began to some of the folks here, everything you see here, I have 5, 10 other examples of a similar Facebook post that my actual clients' employees have done or my clients have done. And these highlight especially how in this day and age, most of the employment law issues we're dealing with take place via Facebook. So let's take a look at some of them. And some of them are humorous, but I will show you quickly how the legal issues sort of flow from this. I always start with Mercy. And again, I don't know any of these people, but Mercy seems like she's become a friend after talking about it for so long. But Mercy says, mashed potatoes and Facebooking at work are making this hangover a little bit better. And a person who presumably her boss jumps on and says, have you forgotten your boss is also on Facebook? And Mercy says, oh, sorry, sorry, Diane, frowny face. Okay, so you may look at this and say, okay, shouldn't have done this, no big deal. But let me tell you how many little things are implicated by a Facebook post like this. Number one, I don't know what this employer's social media policy is. Should she be Facebooking at work? Do they have an incidental use policy? I'm not really sure. Does the fact that she's hungover at work implicate a drug and alcohol policy? Many employers' drug and alcohol policies these days don't even talk about someone being inebriated or intoxicated at work to the point where they can't walk. They talk about having alcohol in their system or drugs in their system. And for some individuals who would send Mercy off for a test, may find that violates a result that she has alcohol in her blood while she's there, or drugs in her blood, may trigger a drug and alcohol policy situation. But also, and this is where I deal with this stuff all the time, also, I don't know, is there an obligation to discipline Mercy because Diane has other employees who have engaged in this behavior and fired them? Is there a discrimination issue here if she doesn't discipline Mercy for this or fire Mercy for this? That's where a lot of people sort of don't think deep into those issues.
Yeah, well, and if she's a heavy equipment operator and she just ran over my car and you knew this, you saw that she posted this, et cetera, and you laughed and said, ha, Mercy, get back to work, et cetera, don't I now come to you and say, wait a minute, she was operating heavy equipment and you did nothing and you knew about it?
Absolutely.
How does the employer, though, under what standard does the employer have an obligation to check that and know that? Because you couldn't expect the employer to monitor Facebook or whatever all day long looking for stuff like this. How would you counsel an employer?
Well, I'll tell you what's great about that. I love this question because it permeates all the Facebook posts we're going to talk about. There's a reason why lawyers, and you probably, everybody listening here has heard this a million times. Lawyers say to managers and supervisors and companies, don't be friends with your coworkers on Facebook. And, sometimes lawyers just say things and people don't really understand why, but you've set up the perfect example for this. If you are a friend or connected to one of your coworkers on Facebook or Twitter or otherwise, although you and I know that it's impossible for someone to be monitoring what your employees say 24/7. I'm not so sure the courts agree. There have been judges who have told me, and I've been involved in cases where judges have said, if you're going to step into that arena, employer, and you're going to connect with your employee that way, you better be monitoring. And if you're not monitoring and you miss something, that's negligence on your behalf. So I warn my clients about this all the time, that I realize you want to be friends with your coworkers. You want to, foster that goodwill and that fun and all that fun stuff that comes from a workplace. But if you're going to do that, you could be charged with the knowledge that this stuff's going on, because the legal standard is not that you knew that Mercy was hungover. It's whether you should have known Mercy was hungover. And maybe you missed the post, but shame on you. A judge would say, as a supervisor, you should be checking this 24/7. And we have more, examples that are more egregious than just someone being at work hungover. We have examples of people being in accidents, driving intoxicated. Those employers should pay attention to it. Same thing with harassment and bullying. Judges are saying, if you're going to connect with your coworkers via Facebook, you need to see if there's bullying or harassment going on. If there is, you better take action. And if you don't, you're negligent for not doing it.
So, to be real specific about it, and this is one of the questions, that's come in already. Like I said, we'll have some time to answer some of these in the end, but as they come in, let me just summarize the question. Are you telling me I should unfriend all my employees or subordinates that report to me in the organization, or just peers or my supervisors? Are you saying that companies should, to avoid that, the expectation then to monitor and to react to what they find. Would that be your recommendation?
Yeah, well, I think we're really focused on the subordinate, boss relationship. So if you're a supervisor, I think the people under you, you should not be connected with them via social media. Coworkers, people your level, because there's not an obligation necessarily for you to step in depending on what the situation is. But as a supervisor, you don't want to connect with your coworker or the people underneath you on Facebook, because then you have an obligation to invoke your harassment policies, your discrimination policies, to report it to others. Now, I will tell you, when lawyers say stuff like that's a completely impractical type thing to say. I realize it's going on. I realize it's going to happen. It's just a matter of how much risk do you want to take as a supervisor. How much risk do you? I will tell you a funny situation. There was a case a few years ago where a lawyer had instructed its client to defriend some of the subordinates, and one of the subordinates sued the employer for retaliation, saying, you only defriended me because I had complained about harassment or something along those lines. So that employer was actually sued for defriending, an individual in the workplace. But I really think it's a matter of how risk tolerant you are. You want to eliminate the risk, defriend away, in my opinion.
Okay.
So on the next slide we have here, this is very typical of what we see on the internet and what I get calls about every day. Typical post, F this job, and then you have the boss weighing in, that's fine, but I'll give your job to somebody else. Couple things here. Number one, you're going to see a theme. I don't love when supervisors or managers or owners respond back to this employee on Facebook. I think from the juries I've encountered, from the judges I've encountered, they think it's very unprofessional to air what is essentially human resources decision on the internet. So it really sometimes hurts my clients' credibility when they fire back like this. But on the general comment about, F this job type of thing, there's a great website out there you should all Google called Fire Me! And what that is that is a site that goes ahead and compiles every day, every minute, every second, all the comments that are out there on Facebook and on Twitter from employees saying, I hate this job, I hate my boss, F my coworkers. It scrolls across the screen like a stock exchange ticker, and that's how often these posts are being thrown out there on the internet. The thing I love about Fire Me, though, I have to say it's pretty cool, is you can go in there and check yourself. So you can put your own Twitter handle in there, and it'll tell you how likely you are to be fired. So I kind of like that feature.
Well, while we're continuing on here, Tyler, Google roads and signing Todd Schill and see if there are any comments that are out there.
Okay, well, here's my favorite example. The next slide here. This is my old buddy Gabe, and I got to tell you, Gabe is clearly one of my favorites because so many legal issues are implicated by this. Gabe starts off by saying, attention San Dimas, California. Tonight's my first night as a pizza delivery guy. So if you find yourself driving behind a Domino's pizza guy, be aware I might be extremely blazed. So there you go, Greg. There's an employee who's driving around, smoking or drinking something, we don't know, but driving around clearly impaired. And Gabe then follows up by says, hey, this job's fantastic. I won't read the actual words here. Dude that ordered a pizza wasn't home. Large pepperoni for Gabe's mouth coming right up. Driving around impaired. If you see a little mobile phone under that last post, that means he's could be texting while he's driving.
And he has the munchies.
And he has the munchies. And he's eating the customer's pizza. And then Gabe goes on to say that he gets a call from his boss regarding this. And then he says, I just met up with a Pizza Hut driver, and this guy's great. He has pizza and marijuana. I love this guy. And then Gabe says Pizza Hut pizza is way better than Domino's. So the question is, what can't you fire Gabe for, right? But think about this. He's disparaging his employer. He's driving around impaired. He's talking about competitors. He's taking customers' product. He's talking about illegal activity. Now, if you're Domino's Pizza here, and you are connected to Gabe via Facebook, and you don't see this, which is what happens typically in these cases, the first thing you say is, hey, I didn't know. But if Gabe gets into a car accident here, hurts himself or another individual, a judge could say to you, you may not have known this was going on, but you should have known. If you're going to connect with Gabe, you better be careful to see what Gabe's doing. So this is just a great example, a real-life example of what we just talked about. In terms of monitoring, and certainly that's a theme for the court that you should be monitoring now, if you turn to the next slide, you'll see that even in the Twitter world, we're seeing situations where here you have a school teacher and she's saying things that are very inappropriate about herself that certainly as a parent you wouldn't want her teaching your kids, but certainly as an employer you wouldn't want her out there teaching your kids. And we see these things every day. You look at Penn Live or other news services every day, you see situations where teachers are doing inappropriate things. Had the employer checked the internet, had they checked this particular person, they would find these things ahead of time. Now, I agree that it's almost impossible in this day and age to keep up with an individual's content, but judges who have sat on the bench for a very long time, may not be social media savvy, somehow think that it's easy to do. And if you step into this world, you better take some action. Moving on to the next post, here we have a situation where an employee is disparaging the company on Facebook. Courtney reaches out and says, I find so many things sad and pathetic, but nothing as pathetic as her former company. And she's disparaging the company. Now, what's funny about this post, if you read on, is that her boss jumps back in, or the owner of her former company, and says, hey, you mean the company that you were supposed to create a social media presence on? Check out our Facebook pages. We're doing pretty well. So this is actually a situation of a person who's fired for not using Facebook at her former employer. But I think the point is that, again, you don't want to be out there communicate with your employees. And let's talk about something else. She's out there making disparaging comments about her employer. Gabe was making disparaging comments about the employer. You could easily, as an employee, walk into a situation where you're engaging in defamation, slander, commercial disparagement, and other really type illegal activities by just a simple post that you put out there. Now, I have to tell you, years ago, I was saying this again before the web started, years ago, if a client called me up and said, hey, look at this post that Courtney just said, I would say, or a current employee, I would say, fire that person. Go ahead and fire that person. But nowadays, we have concerns with doing that. And the biggie that we face every day is something that comes out of the National Labor Relations Act. Even an employer who is non-unionized has to be very careful when you terminate an individual for what they say on social media. Why? Because the National Labor Relations Board and the courts could see it as you're stopping concerted activity, i.e. you're stopping employees from engaging in union organizing. And if people are going to be out there and they're going to be criticizing a company and maybe the terms and conditions of employment, you have to think about whether that person is protected before you fire them. And if you go to the next slide, we'll start talking a little bit about what's protected and what's not. Here's a typical Facebook page. I hate my boss. And another person jumps in, and I think they meant to say ditto, but they said dido instead. The question is, can you fire this individual for saying that? My instant reaction is yes, you can. Why? Because they're not really having a constructive conversation with their coworker about terms and conditions of employment. They're not complaining about the hours, the wages, the salary, the benefits. They're just kind of teeing off on their boss. So I don't think this is really protected activity, but you have to think about that analysis that I just stated. Are they engaging in constructive conversation with their coworkers regarding the terms and conditions of employment, which could lead to a union? Now, person jumped in last time I did this presentation and said, what about all the people that say ditto or people that like a Facebook post about the boss? Can you fire them too? The answer is absolutely. If you have an employee who's out there and they're criticizing the boss in a way like this that you feel is inappropriate, unprofessional, you can take action against a person, even for liking and not adding their own comment. You can certainly do that. But you got to walk through the analysis that I just walked through. In fact, I'll give you one that's a little bit closer. Here, Mandy says, why am I up at 5 a.m.? What kind of moron opens his business at 5 a.m.? And the boss jumps right back in and says, the moron that pays you, well, not for long. So here you have a situation where Mandy is criticizing the boss, calling the boss a moron, calling the company out for their business practice. But so here's my question. If normally you'd say, well, Mandy could be fired, right? Well, I don't know. In this day and age, is she talking about the terms and conditions of employment? Is she saying, I don't like these working hours. I think these working hours are tough on employees. I don't think they're fair to employees. And I don't know whether or not this Richard who responds is a coworker or not. If Richard is a coworker and the two of them go on to have a conversation about the work hours of this company, you're starting to move into protected conduct. So as an employer, you want to really think about those types of things. Same thing with the next post. My boss is such a jerk. He's selfish, low-life prune that doesn't deserve me. And the boss weighs in. I completely agree. I don't deserve you. You have 12 hours to clear out your office. Again, don't fire people on Facebook. But is this protected? I don't think this is, because I think person is just teeing off on their boss. But if they start to talk about, I don't like the benefits here, maybe my boss is selfish because he makes me work on the weekends and others don't, or he doesn't have to, then you start to get into a more protected situation. This is what we have to be very, very careful about these days.
Just a note here, Todd. We're watching our time. We're doing fine on time. We do have about 3 questions. I'm counting 1, 2, 3, 4 questions. 3 questions that have come in because I already answered one of them. We will get to those at the end. So those of you that are sending those questions in, keep them coming, and we will have some time at the end to get back to them.
Okay. Yeah, we'll do that. This is certainly a topic where we could talk for hours and hours and hours. So I'm going to try and run through a couple of these slides so we can get to your questions. So if you look at the next slide, here's a typical situation you see. Rachel, wishing I had my own office today. Somebody's food smells and is making my stomach churn. And does your cell phone's ring have to be so loud and birds chirp? Seriously? And the person who presumably is sitting next to Rachel, oh, whoops, sorry, you can hear that all the way down there? I'll switch over to the disco ring just for you. Clearly, Rachel and Sarah do not like each other. Clearly. But employees now say things to each other via social media they would never say to each other's face. And why is that a problem for employers? Because this is where the communication is that you have to pay attention to. This is where, could this go from a simple coworker dispute to a bullying situation to a harassment situation? Does this trigger the supervisor who is friends on Facebook with Rachel and Sarah having to jump in and stop this activity? I don't know. That's the situations that we're dealing with these days. On the next slide, you'll see another typical comment we see. Blank is making sexy eyes at Lauren across the office right now. Now, okay, person jumps back in and said, you guys need to finish up whatever you're doing. And we want to have lunch. But if you're a supervisor and you're connected to this and you see that one employee is making quote unquote sexy eyes to another employee in the workplace, is this the beginning of sexual harassment? Is this a place you have to jump in? Will this be a piece of harassment evidence down the road? I mean, one thing I know for certain is that this is probably not harassment, because I think guys are certainly incapable of making quote unquote sexy eyes in the workplace. I think it'd be labeled more as creepy or stalkerish or something like that. But you see, if you're a supervisor and you're connected to this, doing nothing, ignoring this is not a good thing. HR director, for example. On the next slide, you see a situation where an employee jokes around, and in that joke, joke according to them, they say they want to stab the boss in the jugular. Now, every time you interview, or I've ever interviewed an employee who makes a comment like this, it's a pseudo-violent comment. This is a violent comment. It's not a pseudo-violent comment. It's a violent comment. They instantly say, oh, I was just joking. Everyone knows me. I'm a lovable person. I didn't mean anything by it. Well, it's not anymore what you intended as the speaker in any of these situations, whether it be harassment or workplace violence. It's how the other people perceive or can perceive you. In this day and age where an employer sees a post that says, I want to stab another employee in the jugular, that employer better take action. That employer better investigate, pull this person out of the workplace, fire this person, do whatever you need to do to prevent that workplace situation. Because you know what? If this person does something violent to this person or another down the road, the employer is going to be called on the carpet that they knew or should have known this person had the propensity for violence. And this post is going to become evidence in a criminal trial or civil trial. So again, while I think a lot of people still do joke a little bit on the internet, I don't think as an employer you can take these things as jokes anymore because of how litigious we are as a society.
I mean, and it's just, it's just the way it is, and there's nothing else we can do about it. I mean, I remember showing up at my high school with my loaded hunting rifle in my vehicle because I was going hunting after school. I remember having my life threatened by a coach publicly many times for bonehead shots I took on the basketball court or whatever. But now that's all different.
It's all different.
All those things are real, legitimate, as if they were put on a bulletin board and signed, sort of threats that have to be responded to. It's it's kind of unbelievable, but now I'm probably showing my age.
Well, I'll
It's
tell you,
unbelievable.
but you're right. It is a very, very different world. I mean, I have HR clients who go out there and look at employees' Facebook posts, and if there's a post out there where maybe the person doesn't threaten violence, but it's starting to seem a little making people uneasy, maybe they're talking about other violent behavior or they're saying things that maybe are not related to the workplace but violent, does an employer these days have the obligation to jump in and stop it? They almost do nowadays, because if you don't do it and something happens, you're sunk. That employer could close the doors.
But the point is a reasonable investigation.
Always.
A reasonable follow-up, not an inquisition, but a reasonable, hey, it looks like this is just some joking around, but it looks like it's becoming a little more serious and we want to have in our workplace, and let's address it type of thing.
Yeah, perhaps, but I'll tell you this. If a person puts on the internet in this day and age that they want to stab another employee in the jugular, you got to question their judgment. You got to question an employee's judgment that would do that. And I really encourage my employers to think that way. If this person did that, maybe they were joking. But what is this person that has no filter going to do next? And that's where I worry a little bit. Along those lines of HR directors kind of searching for people, this is the kind of thing you're seeing in background searches now. Can you do me a favor and remove that picture of me smoking that doobie? I really appreciate it. It's not really good for my reputation when looking for jobs, And the person says, seemingly oblivious to the world, I can remove this, but who would look at Facebook when checking you out for a job? Well, everybody does nowadays. And there are plenty of judges out there that would tell you not only should you be checking this type of thing before you hire someone, that you have an obligation to do it. And if you don't do it, and that person comes into your workplace and commits an act that hurts another or is engaged in harassment, discrimination, whatever, you may be on the hook because you didn't do your homework on this particular person. So that's the kind of thing that we're seeing quite a bit, which certainly I deal with every day. Last Facebook post I want to throw out there, and I have to tell you, this is maybe a little bit more for humor than anything else, but is my favorite by far. And it highlights the last point I made a little bit. Here you have Olivia, and Olivia says, I need a summer job. Does anyone know who's hiring? And Evan jumps in, and Evan is fantastic. Evan says, you should try Redbox. They're always hiring. Olivia says, for real? I thought that was just a movie machine. And Evan, brilliant Evan, says, no, there's a guy inside the box that dispenses movies out to you. It's a really simple job. My buddy works in one. He said there's a TV, there's a mini fridge in there. Go check it out. Just go up to the Redbox, knock on the door, and get the application. And Olivia says, I'll go right now. Very, very cool. Okay. I love Olivia, and every time I drive up to a Redbox, I'm still looking for her to jump out of her car and knock on the door for an application. But imagine Olivia's going for a job, and you're out there and you do a search, and this is what you see Olivia posting. Is an employer going to hire her? Absolutely not. And this is the kind of thing, for all of you out there that have children that are in college or in high school, the things that you post on their websites these days, they don't go away. They're there all the time. Everybody gets them during background searches. And this kind of thing could actually hurt a long-term career. So, this is something we have to really get more education out there, because as Greg said, you'd think that everyone would understand these concepts, but they still don't seem to understand them perfectly.
Well, let's, if you have a question, again, go ahead and forward it. I'm just going to start going through the list of the ones I have here in the order they came in, and we'll address as many of them as we can. And if we can't get to all of them, just feel free to reach out. There'll be some contact information up on your screen right now. You can see. You can email myself or Todd, and we'll get the question to the right place. Well, we'll just start with this one though. This one kind of starts out seriously. Seriously, what percentage of your cases have actually been determined or had the outcome determined by web content, where that was the smoking gun? Is that happening like half the time, or a quarter of the time, or if you had to sort of think back and give kind of an estimate of that?
Yeah, I would say probably about 3/4 of the time. Most of the cases, now, every case doesn't get to a decision, but I'll tell you that cases have been settled, dismissed by a court based on something that happens during a deposition, and most of the time it's about Facebook posts. I'll give you a great example. Not too long ago, a client calls me. They're sued for sexual harassment, and the harasser in the case said that although she joked around from time to time, she never really joked as much as other people in the workplace. She never brought up sex in the workplace. She was very intolerant to that, and everybody knew it. Well, what did we do? We went out and got her Facebook posts, and she forgot to check private, and we got all of her posts from the beginning of time. And sure enough, She talked about sex constantly. She initiated it. People would have a joke that wasn't sexually related. She brought sex into the topic. So at the very end of her deposition, we said, you know what? I have one more question. And she said, what's that? And out we bring a stack of all these Facebook posts. And instantly she forgets what Facebook is. She doesn't remember typing that. She doesn't remember doing that. But there's a great example of how the case absolutely did turn right away. It was dismissed and turned right away on Facebook posts. I would say 3/4 actually do now.
All right. Wow, 3/4. Next question. And another one had just come in. We'll try to get to that one as well. When you do find something, okay, and this is asked from the perspective of an employer. It looks like when you do find something, when do you bring the issue to the employee and how?
Well, every case or every situation is very, very different. But I will say this: at the end of the day, you can't exactly trust everything that's out there on the internet. You got to verify it. I believe if you find something, you take it right to the employee very quickly, and most of the time the law requires you as an HR person or supervisor to do a prompt and thorough investigation. So you take it to the employee right away, but you start with the concept, is this you? Is this what you said? Because I have a lot of situations where the employees say that wasn't me. I didn't post that. A friend used my account. And sometimes they're telling the truth and sometimes they're not. But getting to it quickly, I think, is the key. The courts want to see that you reacted promptly.
Okay. Next question also, again, probably from the perspective of the employer. What is the recourse for companies or bosses in these situations? Is it simply going to amount to having a policy at the onset of employment? Like, what's best practice for, the company to try to mitigate some of this before it even happens?
Yeah, that's a really good question. I think the best thing that employers can do these days is understand the concept. And what does that mean? That means training. All of your managers and supervisors should be trained in social media. We're so used to training employers in sexual harassment, discrimination, and those types of issues, and we're not as good in training them specifically on social media. So what I would do is I would get your groups trained. I would teach supervisors these concepts, probably a little deeper dive than we just did in this last 45 minutes or so, but training is the key. You'll be able to use that in court. You'll be able to show a judge that you weren't acting negligently, that you tried to educate on these concepts and tried to get ahead of these social media issues.
Yeah, this next question is kind of along those same lines. Let me just get it out there for you. Are there issues with companies having varying levels of internet access and at the same time the professional freedom that you discussed?
You mean in terms of employers that have different, how deep do you dive on an employee? Or
I think I'm just going to interpret the questioner's question here a little bit, and hopefully I'm doing a good job doing that. But hey, company A over here says do whatever you need to do on the internet, just get your job done. Company B over here says don't access the internet during the workday, et cetera. You're completely forbidden from being on the internet. We're going to block it with our firewall, blah, 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 all those other kinds of things. So there's these differing levels of access that companies are allowing. And then at the same time, there are companies that have different policies on the freedoms they want to have for their employees. Like, for instance, if you worked here and you said you wanted to check to see if your favorite sports team won a game last night and you were going to go out to ESPN to check that score, we're going to be fine with that because we're going to trust you to do your job. And now, if you said you're going to watch the entire Masters, during the workday, all 4 days, we'd probably have a problem with that. But,
sure.
But again, you're a professional, right? We trust you to get your job done. And I think the questioner is saying here, hey, you have different levels of access provided in the workplace that are by no means consistent. And at the same time, you have two different standards or multiple standards of just extending professional freedom to workers who you trust to get their job done. And the guy stayed an extra hour to get something done, and you were very happy with that. But now you're not going to be happy if he, looks up the time for the movies tonight or something.
Yeah.
You know what I mean?
I do. I think to begin with, every employer has the right to set these policies to be as strict or as lenient as they want to. The employer needs to know that if they do that, they have to treat everybody the same within the workplace, very, very consistently. You have to discipline your best buddy at the workplace if they're violating that policy, just like you would your least favorite person. But from an employee's perspective, a lot of them don't understand that they don't necessarily have even First Amendment privacy rights in the private workplace. For example, employees feel they can go out there and say whatever they want, and an employer can restrict them to a certain extent because they have freedom of speech. And while they do have freedom of speech, an employer can take action against them for what they say on the internet, and they don't have protection for that. So from an employee standpoint, know those policies. How does your employer look at this? It's very important. From an employer standpoint, treat everybody consistently, and again, follow some of the tips I said earlier by looking at a post and thinking about a post, analyzing it before you terminate the person as a result. Okay. But I will say, to your point though, Greg, most of the employers these days that are progressive in these issues have realized that if I don't loosen up a little bit on the social media and I don't let my employees be adults and professionals and do a little bit out there without watching them being very big brother, I'm going to lose good applicants. People won't want to work for this company. They'll go work for Netflix and Google and other companies, McKonly Asbury, that are more kind of lenient with this stuff because they trust individuals as professionals. So I think that's a real practical concern for employers.
Excellent. I'm going to turn it back over to Tyler for a second. Just one additional question I have left, and any others that come in, we'll try to get to them if we can for sake of time. But I'm going to turn it over for Tyler for a couple of from a message from our sponsor, or whatever we would call that, and we'll be right back. Okay, one question that just came in, and then one from the prior session, and we'll start with that one. Can you give us an idea of what it would look like? Somebody says, "Hey, I want to do some training. I want you to come to the workplace." What does that look like? Is that you have all supervisors and employees in the same room, and you kind of say, "We're all in this together. Let me just educate you." Is that a 2-hour deal, a 4-hour deal? I mean, what does it look like?
Yeah, it's not very extensive. You don't need to spend hours and hours and hours on this stuff. But one concept that's very important is to split the training. You do one session for the managers and the supervisors because you have to teach them some pretty high level concepts of their obligations of investigating, seeing the red flags, dealing with social media. Then you have a separate session for employees where you train them about basically thinking about what they put on the internet and how it could affect their job and their lives and things like that. You're talking about a 1-hour training probably for both 1 to 2 hours at most, but certainly in 2 different parts, managers and then your rank and file employees.
And you mentioned that as a possible sort of mitigation because you can at least say to both parties, we did training, we tried in an ever-changing sort of world of technology to do some level of education, and you point back to that in the event that something happens.
Yeah, courts want to see you getting ahead of this. They want to see you educating your people. They realize that you can't catch it all, but if you do nothing in terms of trying to educate, you do look like you're crossing over into the negligence world. So I think this is this training sets you free.
Okay. Another question has just come in. It's more of a comment, but I'll read it and then let you add comment to it if you want. This individual comments, "At my workplace, we've had internet access locked down to only sites that are necessary to do our work because of industry privacy breaches." That is another important point-related issue. Just comment on that if you think that's a good practice. Hey, I'm going to lock down. You don't need ESPN, Todd, to do your job, so I'm going to limit you to legal sites and other kinds of things that are necessary for you to do your job. What do you think of that as a strategy?
Again, I think you're gonna cut out a certain percentage of the workforce that's not going to want to work for you. But beyond that, I don't think it's a bad practice. It eliminates the risk that you as a company are being dragged into some of these posts. Maybe someone's posting illegal material, copyrighted material, etc. via your server. So you stop that kind of stuff. However, as an employer, that's only like 1% of what we deal with. What about everything else your employees doing mobily? You may not give them access to just jump onto ESPN right there at the desktop, but they're going to do it on their phone. They're going to do it on their iPad. They're going to do it any way they can. So I think it's okay to have a policy like that, but as an employer, you have to be practical and recognize they're still going to be out there doing that type of stuff. And that just means better supervision by, focusing more on work product. Are they getting their work done? Are they getting their job duties and responsibilities done? I personally think that's where the focus should be.
Okay. Last question, and then if we hear of no others, we're going to be signing off. So sort of last call for questions. Do you believe in this marketplace there is a sort of a legal obligation for employers to filter internet access? In other words, what employee can get to. The fact that you don't want your employees using the company network to go to terroristic sites or to adult material, other kinds of things like that. Is there an obligation, you think, in this marketplace for companies that are providing the access to also do that?
Yeah, I think there is an obligation. The question is to what extent. The courts will want you to do something. And if something is simply that you're just going to block offending sites, that's at least something you can argue down the road if an employee does something inappropriate. Hey, we tried to do something. So I don't have a problem with that. I think there is an obligation. The employers that I see getting in trouble are those that don't do anything. They don't monitor, they don't block, they don't train their employees, they don't go out there and search and do background checks via Google and other systems to find things on their applicants and their current employees. Those are the employees getting in trouble. Everybody else, you do a little bit, I think goes a long way.
Okay, excellent. Well, that does answer the questions that we've had come in. Again, contact information is on your screen. If there's something that you were dying to ask, but you want to ask in a more specific situation as it relates to your company, etc., please go ahead and email. You can email Todd directly or me, and I'll make sure we get it to the right source. Todd, thanks again for being here. Always do a good job on these webinars. You're one of our few repeat guests so far. We really appreciate you coming in.
Thank you, Greg. Appreciate it.
Thank you once again for joining us for this presentation produced by McKonly Asbury. We hope you join us and participate in our upcoming events. You can stay up to date with news and learn about our upcoming events by visiting us at www.macpas.com. Thanks again and have a great day.